So listen, welcome everybody. Glad to have you back. Another very important Zoom call. Of course, this time we're talking about a second discussion on the PREVAIL Act. But before we start, a couple things. One, anything you hear on this call or any call we have is not to be considered legal advice, even if it's coming from an attorney. Definitely, if you hear something you want legal advice on, get with an attorney or your attorney on that. Secondly, we're going to, so you can put your questions, any questions you have in the chat, but basically we're going to try to provide questions to the speakers at various points during the talk where they've finished their presentation and they're ready to take questions. And we'll try to get to the questions we can. We'll do what we can. This is a big call. We have a lot of people on it, a lot of people watching, people from various places, some pretty important individuals. And the purpose of this is to really dig into the bill and to inform our efforts on coming up with an official position of U.S. inventor. And so we don't have an official position yet, but we're looking closely and we really want to bring out all the details. So the mission of U.S. Inventor, as any of you who've been on these calls before, is to restore to inventors and startups the rights that you're supposed to have, that our Constitution says you have, that inventors and patent holders had in America for a very long time, up until recent years. And as any of you know, you can go to our website, usinventor.org, and see what has happened through a couple of bad Supreme Court decisions and a really bad piece of legislation, the American Invents Act. So we're fighting to change that back to what it should be. And of course, the bill we're going to talk about today, the PREVAIL Act, deals with one of those specific areas, which is the Patent Trial and Appeal Board, the PTAB, which is the administrative court, which for any of you who aren't really up on this, prior to the American Invents Act, you had a real court where you fought your fights with a real jury, with a judge, with due process, a lot of due process. Now, a lot of these fights end up in this administrative court that we find to be very unjust for inventors. So we're going to talk about that today. That's what this bill is supposed to rein in and to change in a positive direction. So we have some great speakers today. We have Chief Judge Randall Rader, who's by the way famous for way back, kind of at the early point of the PTAB, saying that it was, I think if I have it right, it's a killing field for patent rights. Did I quote that right?
I think I called it a death squad, but you're pretty close.
Okay. But we're going to have Judge Rader start the discussion. We have Matt Dowd, who is an attorney who does, it's with Dowd Sheffel, does a lot of litigation and appellate type work as well. Very knowledgeable on this issue. And we also have Jonathan Rogers with us, who's this Chief Operating Officer of Centripetal, which is a company that has very successful in providing cybersecurity solutions. They have been attacked at the PTAB numerous times. Jonathan was one of the key witnesses at a hearing at the IP subcommittee in Congress on the PTAB last year. So got a good group of people here, and we're gonna let Judge Rader start off. And when we get to a particular element of the bill, we may actually just kind of stop and have each of the panelists here give their thoughts on that particular element as well. But go ahead, Judge.
Thank you, Randy. It's a pleasure to be with everyone today. I think we're talking about the biggest change of the last 2 decades in patent law, and one which has had an extremely detrimental effect upon the incentives for innovation and invention in our economy. The creation of the PTAB, which was enacted in 2011 and went into effect in 2013, essentially took validity and created a separate proceeding for it in the patent office. Now, validity is a defense to patent infringement. It is meant to be litigated in the context of a defense. It is meant to be litigated at the time of the infringement proceeding. But instead, this Act, the America Inventors Act, pulled that defense out of context and made the Patent Office the only agency I know of that has close to 300 adjudicators who are trying to retract the very rights created by the Patent Office. This PREVAIL Act is an attempt to restore a little balance. It's not going to put the validity defense back into its proper context, but it is going to take a step towards bringing balance to the procedure that happens at the Patent Office. The two most important provisions, which I would urge us to concentrate on as we go forward here, Randy and others, is the estoppel provision, which puts an end to all further attempts to adjudicate any issue of validity once that is filed in a petition. There is currently an estoppel in the bill, but it doesn't go into effect until a final written decision, which happens in a tiny percentage of the cases. So this estoppel would cause some reconsideration of whether you really want to adjudicate validity in its proper context at the trial court, or go to the PTAB before administrative patent judges. The other provision of importance is the burden of proof, which reinstates the presumption of validity for these issued patents. They are issued patents, and because they have a presumption of validity, you have to prove by clear and convincing evidence that they are invalid. And the current PTAB standard is just a preponderance, a much lower standard of proof, and is the reason most defendants go to the PTAB. They get a 2-year delay in the process. They get a sympathetic group of adjudicators, and they get a lower standard of proof. Well, I think the PREVAIL Act is a step in the right direction, and I would urge you inventors to support it. Thank you, Randy. Does that get us going?
Yeah, and I have a question, and of course, I definitely want to let our other, in fact, maybe I'll start and say that maybe with Matthew. Matthew, do you have any thing you'd like to say about what the Judge Rader has brought up?
Oh, well, Randy,
or anything else?
Randy, thank you for having me. In terms of Judge Rader's comments, I agree wholeheartedly. There are a fair number of provisions, even beyond the estoppel and the burden of proof, in here. Those are, I agree, some of the most important, but there are certainly other aspects of the PREVAIL Act that will go a long way in terms of balancing the rights of innovators and inventors and restoring those rights and the procedural rights, which are important, to what the status quo was, perhaps maybe not in 2011, but we want to get back to maybe prior to eBay, prior to KSR. We have these line of Supreme Court cases basically since 2006, 2007 that have really weakened patent rights generally. I know some of that is probably beyond the context or the scope of the discussion today, But those decisions have contributed to an environment that have exacerbated the problems caused by the PTAB. And if we all are very familiar, the PTAB, the focus, or at least the one of the stated goals, was to make patent validity determinations quicker and more efficient, less expensive for everyone. Probably everyone on this call understands that that hasn't been the case. We haven't seen that come to fruition. Hopefully we'll hear from Jonathan Rogers from Centripetal in a second. He has some nightmare stories about his company and what he's experienced at the PTAB. I'll keep it short initially. One of the other things I think hopefully we'll talk about moving forward is the incentive consideration in terms how the PTAB is set up, what it ultimately does, the fees that it generates for the office, and how those incentives essentially drive a system that, in my view, often requires the PTAB to have an invalidation rate that is a particular level. Hopefully we'll talk about this later, but in short, imagine a situation if the invalidation rates, or the cancellation rates to be more technical or precise, at the PTAB suddenly dropped low, 20-25%, then the major users of the PTAB might no longer go there, and they would go back to district court where these proceedings should be decided. But it's an inherent system, or an inherent incentive, that I think many feel and rightfully believe that the structure of the PTAB, in terms of paying for these proceedings, paying for the petitions, the large amounts of money that are generated, drives incentives in a way that, at a minimum, give the appearance that it's not a fair process. So that's a little outside the specific provisions of the PREVAIL Act that we'll talk about, but I do think it's worth perhaps talking a little later about that. So I'll leave my initial comments in that and turn it back to you all.
Yeah, and thanks for that. And we will definitely talk about that. Jonathan, just at this initial point, any thoughts on what we've brought up so far, or anything else you want to talk?
Well, my technical analysis of the law and all of that will certainly not be on par with Judge Rader or with Matthew, but I can say that the PTAB is a domain that has opened up an incredible amount of malfeasance, and I say that from the school of hard knocks, in that we have had the PTAB used against us probably somewhere between 50 and 75 times now. We have faced invalidation cases at the PTAB. And when you think about it, the PTAB is really quite a remarkable thing, in that in the history of our country, we had this concept of separation of powers, where the judiciary was set up to be the arm that dealt with disputes between private parties, and that and civil litigation and private disputes would all be handled by this separate and independent branch that had many different protections, evidentiary protections, due process, as well as the lifetime appointment and tenure. And what the AIA did was it took an administrative function that really was designed to deal with disputes between the government and a private party, and it's now set up a politically controlled body that adjudicates private party disputes. And private party disputes and intellectual property is where the entire private sector can be driven. So, and they don't have lifetime appointment. They don't have ethical controls, and the career trajectory of the individuals who work there is certainly much more likely to have a future on one side, on the petitioner side, than on the side of the defendant. And so, we see really remarkable things happening in ethics and due process and the way the whole system is being run. So I've come to the conclusion that I think that the PTAB is structurally very problematic in the way that it was designed. And that the goal that we have to have at this point is reducing the interactions that happen between inventors and the PTAB. Ideally, we would say, all right, the PTAB should be abolished, and it should be handled in the domain of an Article III court with the full access to the federal rules of evidence, all of the protections of discovery. As Judge Rader pointed out, being able to handle validity in the defense posture that it's supposed to be handled in the context of infringement by an independent jury. But the reality is that this is a highly charged political battle where progress is measured in inches, not in miles. And so I think that anything that can reduce the interactions and the potential for malfeasance on a pathway towards an eventual zero is certainly something that I'm in favor of. And I think that from what I know about the PREVAIL Act, I think it might be better to think of it as the PREVENT Act. There's a number of classes of malfeasance from our experience that I'll get into that could have been prevented.
All right. Well, thank you for that. I'm sure there's a tremendous amount of agreement among the viewers to what you've said. I have a question for Judge Rader, because Judge, you mentioned this thing about, there's a part of the bill called single forum, which has to do with if you have, in other words, you shouldn't be facing an effort to invalidate your patent at PTAB and in district court, et cetera. But I want to tell you something. I'm looking at the actual language, and I'm actually looking at it right here. Single forum. In general, if an inter partes review is instituted, challenge the validity of a patent, petitioner or real party of interest or privy of the petitioner may not file or maintain, and they basically go on to explain how they can't attack you in these other venues once it's instituted. The problem there is it has to be instituted. So in other words, it should be, if they're really trying to do what they're saying, it should be if it's petitioned. Because if you're waiting till institution, then basically the party that's being accused of infringement can go after you in all the venues, and you're having to lawyer up and fight on all the venues. And if they don't get institution, then you can still go to validity challenge in an actual court. Because further, one section down from that in the bill, it actually says that just because you have sued them, just because they're trying to invalidate you in another venue, does not stop the director from allowing you to be instituted into a PTAB trial. So it seems to be, even though they're claiming one thing, the actual wording of the bill seems to be really weighted toward the infringer.
To clarify what Randy is pointing out, there are two cutoff points we're talking about here. The filing of the petition, which is when someone attacks the validity of a patent by filing a petition at the PTAB. The act, the PREVAIL Act, doesn't institute estoppel at that point. It waits until the PTAB has actually received the petition, received the response, and then instituted a PTAB proceeding. At that point, estoppel kicks in. You could, in theory, Randy, move it back to the point where the petition is filed, because at that point they have made a selection to go to the PTAB. But they could, upon seeing the response, recognize that their petition is not valid and withdraw it. And I think it makes sense to wait until actual institution at the PTAB, because that gives some discretion on the part of the petition filer to withdraw a weak petition, and that makes sense. I can see that there would be more protection for patent owners if the estoppel happened earlier at the petition phase. But I do think there's certain wisdom in waiting to institution.
I mean, I think what we'd like to see is if they decide to go one way or the other, they can't, then they go that way and they can't go the other way. And that would be at the very beginning. But I hear what you're saying.
Yeah, well, the trouble is, what are they going with? You make one argument based on some prior art, and then you may realize, hey, I've got completely the wrong prior art here. I need to revise this petition. And this would allow that kind of judgment as to what is the proper challenge. But once that challenge is instituted, that would cut off any opportunity to use the district court for a similar challenge later.
So currently, when you're in the ITC, you can't stay the ITC proceedings to go to the PTAB. There's I've read
well, you can technically, Paul. It doesn't make sense under the time limits. They both have a 1-year time limit, and so by the time the International Trade Commission has started its proceeding, it can't stop for a year without violating its own statutory time limits. So in fact, you can have a stay, but it would only happen in the rare instance that someone had filed a petition many months before the ITC proceeding began. And
Does
even
this change-
then, the ITC judges feel like they can do validity. And that's right. They should be doing validity in the context of the infringement case. And so I like the way things proceed at the ITC in most instances. Sorry for jumping in there, Paul.
Well, that's okay. I'm just trying to understand, and for the people listening, if you're in the ITC and you're trying to get an exclusion order, which applies to anything manufactured overseas, and you have a patent to, the Coast Guard or the border will stop it from coming in. It's similar to an injunction, but I saw there were changes in there that had to do with the ITC. Does this, if I'm in the ITC and somebody puts me in the PTAB, this doesn't stop the ITC proceedings, is that right?
No, it doesn't.
Okay.
The ITC would have to themselves stay their proceeding, and because of the overlapping time limits, it almost never happens.
Now standing, let's move on. Well, does anybody have anything else on that they want to?
I have a question.
I'd like to
on
kind of
standing.
walk through a few of these provisions real quick so that.
I have a question on standing. So it's great that they now want to require standing. However, I have a question. If now standing is required in order to invalidate a patent. So let's say, what does it matter for the patent owner? Like, what good is it to the patent owner when you still get forced into the PTAB? There is no once you sue someone, because there has to be standing. Once you sue someone, then they have standing, and then you end up in court, and they'll just force you into the PTAB anyway. So what good does it matter?
I could give a practical run through on this one if it's all right, Randy.
Yeah.
Yeah.
Mm-hmm.
So these IP battles are really, really complex, lengthy, costly, and difficult. And I think to answer this question, you have to back up and show what's going on in the industry, which is late stage companies like the American big tech companies. As they grow and get larger and larger, they become less innovative of themselves. And their business model depends much more on distribution, the sales forces that they have, the channels that they control, the markets that they can reach. And they're looking to simply, they have an interest in basically having an open source economy, where there's no restriction on being able to take new technology rapidly, put it into the channels that they've built, and get it distributed. And there's a lot of companies now at the top that are in that position. So in our battle with Cisco, for example, we fought our way through. They sent an onslaught of 17 IPRs. We prevailed on many of them. We got to district court. When we got to district court, we got access to so much more evidence through discovery that showed even the ones that were instituted really shouldn't have been, and that the whole matter should have been handled in district court. But we won, and then we won in the district court. And after we won in the district court, their, tacitly collusive companion, another industry competitor, Palo Alto Networks, comes and decides that they want to try to pick off every single patent that was part of that, just to exert leverage upon us. Hundreds of patents in our portfolio. They picked every one of the ones that underlied the judgment that they were not a part of to come and try and gain leverage. And the patent office, did their bidding in that and allowed them to institute a time-barred case with respect to Cisco systems, without standing with respect to Palo Alto. And the judge who did it, the PTAB judge who did it, owns Cisco stock.
God.
So standing is a big deal in that at least you can make it a difficult one-way fight. If you have to open yourself up to getting gang tackled by the whole industry, it's like trying to win a four-way verbal argument. You can't. You'll be drowned out by the noise and by the cost. And so I think standing is absolutely essential, and it's probably the biggest improvement in my view that could be made, because at least it puts a boundary on this horrific process.
So on the standing language, Matt, maybe you can help on this. The way that it says is you can't file at the PTAB unless you have Article 3 standing. You think you're going to get sued and you got proof that you've been threatened or you have been sued. But there's another part of that I don't quite understand, where they're talking about the next part of that provision, where they're talking about if you have financial incentives to them and all kinds of stuff. What does that actually mean? What are they talking about when they have the standing? And then also, I didn't know if that's an exception that allows unified patents to continue to file patents, or if it means they're getting rid of them altogether.
Yeah, I could add some thoughts on this. So when you look at standing, and this sort of goes back to Dirk's original question, right? A typical and a very traditional patent fight would be if the patent owner sues the accused infringer, and there's an Article 3 case or controversy between those two parties. And that's how then you would then litigate infringement. And as Judge Rader noted, you'd also litigate validity at the same time. The courts and the law has traditionally, for many, many years, been that, well, you can't just have any outsider come in and be an intermeddler about these private property rights. And that's the requirement for standing. So in many instances, Dirk, like this revision in the PREVAIL Act, or this proposed amendment, it won't affect a lot of cases. But as Jonathan explained, it will remedy a lot of abuses in very important cases, right? So I think, Dirk, you recognize that, yes, for some members of U.S. inventors, that provision may not be important, because if you sue the big company or the accused infringer, yes, that's not going to change whether they could bring you to the PTAB. Other provisions may, right? Now, I think to Paul's question, right, in terms of standing, there are different views on it, and in terms of who has standing. A very simple focus, which we've been talking about, is if the party has been accused of infringement, right? You've actually been accused of doing something wrong, and you've been sued for doing something wrong. That is the simplest basis for establishing a case or controversy under Article 3 of the Constitution, and therefore you have standing. There are some other views and other theories that, well, you may not necessarily have to have been sued for infringement yet, but you may have a financial interest or incentive that is strong enough to show that you have standing to challenge the patent. Maybe you have plans moving forward. Maybe you've invested monetary resources or employment resources, and maybe that's enough to show that even though you haven't been sued yet, you have an interest of canceling that patent. So it's sort of like a broader scope of Article 3 standing. Now, your question, Paul, also as well, whether that would cover an entity like Unified Patents. I can't really speak to that specifically. I think, as I understand it, the purpose of the provision or the amendment is to get rid of those instances where you have for-profit entities whose sole business is to go out there and challenge patents on the basis of their membership. And I think that there's a strong argument to say that, yes, you shouldn't have these third-party funded entities going out just canceling patents. Now, from a very simple perspective, right, you could say that, well, those companies, like a company like Unified, is acting on behalf of, say, a company like Cisco, one of its members. This proposed amendment to standing really will have no detrimental effect to accused infringer like that, because all it means is that that accused infringer, instead of hiring some third-party mercenary to do their battle, they just have to go to court or go to the PTAB and challenge the patent themselves. So I think
let me read this particular clause. It's under necessary conditions. Person may not file with the office a petition to institute an inter partes review of a patent unless the person or a real party in interest or a privy of the person has been sued for infringement or charged for infringement. I guess that's the part I'm confused on. Does that mean that Unified Patents can still have somebody who's a real party of interest that they're filing that for? Can somebody still operate for someone else?
But if I understand it correctly, in that particular instance, based on that language, Unified would not be, they've taken the position that they're not a real party in interest in all of these cases on behalf of their members. They're doing it independently. They choose to decide which patents, and therefore they would not qualify as a real party in interest.
The key there is privity. They are not a party to the case contractually or in reality. So the bottom line of the standing provision is you really only get to go to the PTAB if you've been sued in the district court. That's the effect of it.
Okay.
I want to respond to what Dirk said. You know, Dirk, to a lot of I know numerous individuals who are members of our group who didn't get PTAB'd multiple times. They got PTAB'd once and it destroyed them, like Dirk and Molly, like the doctor who invented the heart valve replacement that's going to save a lot of lives of people on this call one day, et cetera. And so yeah, even though the more egregious aspects that large entities like Jonathan face, and a lot of people have faced, yes, it's good that there is an effort to get rid of those. But as Dirk said, just being at the PTAB period one time can destroy you, and that's a problem. So
yeah. A quick question back on the issue that Judge Rader raised on the point that a PTAB proceeding should really be dealing, or at least invalidity should be coupled to infringement. And isn't it a real consequential issue when it comes to claim construction? When you construe claims in invalidity alone, and you're not tied to having to then meet the claim construction that deals with infringement, a patent challenger may actually push for a very broad construction at the PTAB, but not so at Article 3 court when he's faced with infringement. So it's really a consequential issue. It's the real policy reason why infringement and validity must be dealt with together because of the claim construction. Is that right, Judge Rader?
Absolutely. I wish I'd said that, Ron. You said it beautifully and correctly, that you really can't separate the defense from the infringement charge without decoupling the claim construction and leading to an overly broad construction for infringement and overly narrow for validity. You're
No, it's
right.
the other way around. It's
Well,
it's
yeah,
the other way
okay,
around.
but you're
Yeah.
right on.
Yeah. Yeah. So that's a point. And I guess that question goes to Jonathan's experience, whether he has seen that activities in a court in Article 3 and PTAB has been, somewhat different because of the claim construction. Have you experienced this type of tension?
Well, absolutely. And I was just musing to myself how well you described it and put words to it, because they're going to the PTAB and they're saying to the PTAB, quite literally, this patent covers everything. And then they're going to the district court and they're saying this patent covers nothing. Right.
This is the PTAB procedure has its origins in European practice, where they separate the validity proceedings from the infringement proceeding. And Ron captured perfectly the largest criticism of that separation, is that you then can overemphasize the breadth or the narrowness, depending upon what you need to do for validity or infringement. In separate proceedings, that's possible. It's not possible when you keep the defense linked to the original claim for which it is a defense.
And that is part of the reason why we have a fundamental discrepancy between cancellation rate at the PTAB, where claims are interpreted more broadly than you would find at the federal court. Adding to it, for sure, you add the standard of proof, which is more difficult in court, pretty clear and convincing. But that is the fundamental issue. That's part of the incentive structure. It's just the decoupling claim construction. So a question to Matt: do you think that another provision could be helped in this PREVAIL Act if the court has a claim construction already, that the PTAB must adopt it? In other words, the PTAB should not be free to come up with its own independent claim construction than the one that a court might have already arrived at.
So to me, that's a very reasonable proposal. I think to be fair, I think it probably happens in a large number of cases, but not always.
Mhm.
And it's the minor number of cases, right, where when it doesn't happen is problematic.
Yeah.
And bad actors, those trying to game the system, don't always get caught, and things do slip through. There is no per se requirement, right, that a claim construction in one form necessarily has to be adopted in the other. After all, as Judge Rader could probably explain better than I could, claim construction is based on the evidence that's presented before the tribunal, and you may have different evidence before the PTAB versus that before the district court, and there may be reasons to come to different constructions based on the evidence available. But all the more, that's we have lots of case law that guides courts and guides the PTO to come to what is the single correct claim construction. All the more reason to, again, have these proceedings, validity, claim construction, and infringement decided in the same
Together. Yeah.
Who decided to copy the European system? Geez.
Well, they copied the European system, but left out the saving grace, which is that the Europeans will let you narrow your claim and keep the rights.
Mm.
Whereas in the US, if
they-
there's any amendment, it's gone.
They did it in the interest of harmonization.
He's putting
So
an emphasis on harm.
I get that.
It has nothing to do with the cessation part there. And I think it was a big mistake. And it's a classic example of unintended consequences in legislation. They thought they were attacking just the low quality patents, as they called them. Of course, it's now more than a decade later, and we still have more low quality patents than anything else. The system is not designed to protect intellectual property rights. It's designed to undermine those rights, and it does it.
So it seems that, go ahead, Ron. When you're done, I'll talk.
So I guess the issue that maybe in time to discuss is really the incentives in terms of the PTAB. One area that is not addressed at all in an otherwise pretty good set of provisions in the PREVAIL Act is the issue of incentives for APJs themselves, personal incentives for APJs. And this is something that Matt has addressed, and I've addressed in the paper on the bonuses of APJs that were increasingly problematic. Do you believe, the panelists here, do you believe that making PTAB judges ALJs rather than APJs, administrative law judges, for which there are statutory prohibitions for bonuses and performance reviews, and so they're going to appear, at least appear, more objective and uninterested in their personal gain? Could that be something that could be adopted at the PTAB, that they will be ALJs rather than APJs?
Ron, let me jump in there for a second. As Ron alluded to, we have a case that's currently pending before the Federal Circuit, and it does deal with the financial incentives and the structure of the PTAB and some of the problems associated with it. Let me just put aside for the moment this distinction between ALJs and APJs. I think it's important, but it's a very, very technical issue that may not resonate as much with the members of US Inventor. But what I'd like to focus on are two things. Basically, just the financial incentive of the system and how it's structured. Because as I'm sure everybody on the call knows, petitioners have to pay a large fee to file a petition. And if it's not instituted, they get refunded a portion of that fee. In the case that I am handling, and this is from 2001, the AIA or the PTAB generated $57 million in fees for AIA proceedings. 34 of that was just for the institution phase. 23 of that was if it proceeded through trial and the entire fee was retained. So you have a body within the PTO that's structured to generate 50, 60, 70 million dollars in fees every year. And they have a set of customers, and we know the most popular customers of the PTAB, the major tech companies for the most part. And imagine a different situation where next year, for example, the PTAB suddenly decides, well, we're not going to institute so many proceedings. Instead of 60%, we'll just drop it down to 20%. And then the customers might second guess us and say, well, this is not worth our time and money. And then it's a spiral, and then they lose customers, right? So the point ultimately is that the way the PTAB is financially structured in their decision-making process and the payment process, we believe, and I think it's at a minimum, right, it's the appearance of it, is that the PTAB is incentivized to grant a certain number of proceedings each year. In other words, right, you could think of it as the PTAB competing with the district court for patent cases. And if the PTAB is not friendly enough to their major customers, then those customers may then go to the district court. Now we don't see that happening necessarily, but that's the problem. That's one of the problems that I see the way it's structured now. And of course, the PREVAIL Act isn't dealing with this. The second thing I'd like to note is, and this slightly goes to the ALJ versus APJ issue, but it goes directly to Jonathan Rogers' case where he mentioned that he had a APJ who was making a decision, right, that was adverse to Jonathan's company, Centripetal, very, very favorable to Cisco, which was at the time one of the parties involved, or later became involved in that PTAB proceeding. And the APJ owned up to $5,000 in stock, or it was up to $15,000 in Cisco stock. Knowing that by granting that petition against Jonathan's company, that it could ultimately favor Cisco and therefore anyone who owns Cisco stock, right? Now, under the current system and under the current government ethics rules, that, at least according to the government, is permissible. I think that's outrageous, right? Those two things in terms of the financial incentives, I think are tremendously problematic, and I would like to see them addressed.
One more point on the incentive, financial incentive. Isn't it also magnified by the fact that the PTO knowingly subsidizes petitioners by essentially charging less for the total process of petitioning and adjudication in the trial than their cost? They admitted as much. They had argued, even in your case, that they're running these proceedings at a loss, but they really don't lose any money. It's the patent applicants who subsidize that, who have nothing to do with the PTAB. We are paying more higher fees on patent applications, and they are charging petitioners about 30, 40, 50% less than their admitted cost to run the proceeding. That's a subsidy for petitioners that really imbalances the incentives. If you raise the fees for how much petitioners have to charge based on their cost, that may cut down significantly the number of petitioners willing to move forward with $80,000 or $90,000 versus $50,000 upfront.
Right.
So shouldn't Congress actually tell the PTO, just charge what it costs you, don't subsidize it?
So I think, Ron, that's a very, very good point. Right, it goes into the accounting and the cost. And listen, we have to take the government's word for it, or at least the agency's word for it, that their accounting and their cost basis is actually accurate. That's a whole nother story. But how about a different proposal, right? And this is, again, I'm not suggesting that anyone, object to the PREVAIL Act based on this proposal. It's something to consider. But would it be a better situation if the PTAB were more a voluntary process where both sides had to agree to participate, right? Now,
that's all the copyrights are, right?
Right, exactly. And so the U.S. Copyright Office recently, within the past year or so, established, through an act of Congress, I believe, the Copyright Claims Board, which is essentially a small claims board for adjudicating copyright infringement proceedings. I believe it's for anything that's valued less than $30,000. It's actually been surprisingly successful and popular. But the key point of that is that it's voluntary. Both sides have to agree to it. And that could be an addition to the PREVAIL Act or a modification or something to that effect that maybe balances it out. Because I'll stop for a second because I know Judge Rader has a comment, but maybe there are some instances where it is beneficial to the smaller inventor or innovator to go through a PTAB proceeding. And
under no circumstance would any patent owner ever agree to go to the PTAB. It's a 2-year delay. It adds a second proceeding before you can adjudicate your infringement. It multiplies your expenses, delays your time period. I can't imagine the small inventor wanting to double the time and expense of bringing a proceeding. So under no circumstances would any patent owner in their right mind consent to go to the PTAB.
Well, this is exactly what would make the PTAB what it was intended to be.
Oh, yeah,
Yeah,
you can
isn't that-
kill it, but if you're
faster
gonna
and
do that,
cheaper
just go ahead and,
alternative.
repeal it.
But Judge Rader, isn't the point you're making really counter what Congress said in a
Right.
report on the act, saying this is an alternative, cheaper and lower cost alternative for adjudication? So what you're saying is basically saying whatever instrument you created, Congress, doesn't really meet your goal of
Ron,
being an
you're
alternative.
exactly right. I said from the outset that this was a product of unintended consequences. Congress thought they were doing something low-cost alternative to help district courts. What they were doing was entirely different,
But
very
isn't it true?
destructive. And
but
you're
isn't it true?
right, but you're not going to, in the first place, you're never going to enact that provision because it
So
kills
let-
the PTAB rather
let
than.
me,
But
let me summarize a
if you
couple
accept
things.
Matt's position that changes will be made, wouldn't be a test for the reasonableness of the end result be the option of the patent holder not to participate? That would basically prove a balanced system, wouldn't it? After amendment.
By the time you fixed all of the issues with the PTAB to make a patent owner want to voluntarily go there, it would be the district court.
Yeah, exactly.
In the interest of,
I like the devilish humor with which you make these suggestions, Matt and Ron, and I
Yeah.
agree that it would achieve the purpose of repealing the PTAB. But
Yeah.
you might as well state it from the outset that that's really what you're trying to do, is go back to the beginning. And since this is really not quite an effort to repeal the PTAB, but to provide some balance in its proceedings, you probably shouldn't put a poison pill into it.
so
Even
let's
though I
talk
love
about
the
this.
devilish humor involved in your suggestion.
Oh, I would
Let's talk
never
about
be so
one thing.
devilish.
Well, what do you got?
I think overall, people here on the panel have agreed that most of the provisions in the PREVAIL Act will have some sort of positive effect. But I got a couple of larger questions. First, given the incentives that the PTAB has to keep invalidation rates higher than the courts in order to attract petitions, is it possible that the PTAB could initiate more rules that are not addressed by this, that we will have to come back in 2 years and ask Congress to address because we have more gamesmanship in different places? Is it possible that this is going to have only a marginal effect? What effect? My concern is that I want to get the hell out of Washington. And we pass this and we're stuck here for another 2 years, and I'm beating on doors for 2 more years talking about what went wrong this time and asking for more legislation. It should have a lasting effect. And what other things are not addressed in this, given that the PTAB to stay in business has to have a higher invalidation rate to keep that invalidation down? And I don't know. If you got any comments on that, I'd sure like to know, because I want to go home.
In other words, how do we stop this process of we will build it and they will come? That's really what's happening. And there's an incentive to build some structures that attract challengers to the PTAB.
Yeah. It would make nothing but sense, given the fact that the patent owner that received a government backed document that says that you can protect your invention with this document would at least have a say into, I want to stay in court, or yes, I want to go to the PTAB. It's nothing but common logic sense.
I think as much as I sympathize with the desire to have a omnibus solution and to go home, I think that the opponents are fierce, and I think that this is an area where progress, like I said at the beginning, is measured in inches. And the opponents are very, very good at incrementally expanding their tools. And as they made progress with the AIA, then the next thing they want to do, they've created a valley of death. Then the next thing they want to do is they want to cut off the funding that gets you through the death. So you hear all of this policy about litigation funding and turning that off and just cinching down. And I think that the strategy that has to work for patent owners is to start reducing the instances of usage of the PTAB. So, there shouldn't be gang tackling. There shouldn't be serial petitions. There should be respect for the district court process when it has happened. There should be standing. And as we start to chip away at this, then we can focus on each of the areas of abuse that ultimately is going to make the PTAB unviable. Because then you can get into the issues of the claim construction, what happens during a proceeding, the evidentiary limitations. And by the time all of that is fixed, the independence, the bonuses, the ethics, the revolving door, then it substantively becomes something different. But it's going to have to be bitten one hard battle at a time.
I think by the time that battle is won, that we're going to be trailing so far behind other countries that we'll never be able to catch up with them anymore.
That risk is running.
Yeah, but
that's one reason why we have the potential
on another Zoom call too.
Let's get through. We got a whole bunch of questions from the audience here. This one's from Mark Riley. It's the last question or the first question. It's at the bottom end of this. I'll read it real quickly and then anybody can answer. Question for Judge Rader or anyone who chooses to comment. As I recall, Chevron deference was used to underpin the Cuso speed decision at SCOTUS, and it was Cuso speed that confirmed the ability to choose the broadest reasonable interpretation. Now that SCOTUS is willing to reconsider Chevron deference in its next session, does that suggest that the use of the BRI at the PTAB may be at risk if Chevron deference is significantly changed?
Well,
It's no longer used. There's a new rule, but go ahead, Judge Rader.
Chevron deference means that the courts have to follow the administrative agency's interpretation of the statute rather than make their own reading of the statute to get things right. The Quatso opinion dealt with the broadest reasonable interpretation of the claims, which we discussed this earlier with Ron, that they can broadly construe claims during the validity proceeding and narrowly construe them for infringement. And since those proceedings are now separate, it's easier to do. In fact, it's been changed, so they no longer use the broadest reasonable interpretation at the PTAB. They're supposed to follow the same rules as the district court. But I think Ron put his finger on it when he said they're still just looking at validity, so they can still overemphasize the breadth of the claims, so they fall within the prior art, and not have to worry about that affecting the infringement proceeding because they're not involved together. So a lot of moving parts here, but the bottom line, getting rid of Chevron deference will help us. It'll mean the courts will make the final decisions instead of a patent office director making one policy, the administration changing, and it becomes a different policy, and then shifting back and forth as administrations change. There will be a little more certainty and predictability. So Chevron deference removal is a good thing. The other point we're still looking at is whether or not claim construction is somehow skewed at the PTAB because it's not in the proper context of a full infringement proceeding. And that is still a problem and is inherent in a system of divided proceedings.
I got another question here from Richard Orbringer, and it's probably Jonathan Rogers. This might be the question for you. Overall, will the PREVAIL Act serve to improve motivation and inspiration of inventors and help build the U.S. economy to be more competitive internationally?
Overall, I think so. And the reason I think so is that from my experience, the PTAB was sold under the theory that there's all these bad patents. And that's not the case. As we've been through, we've rarely run into one of these overbroad attacks that couldn't be easily prosecuted around if you take it at face value, which the PTAB makes you take this overbroad attack that would never fly at district court at face value. And if you can address a lot of the malfeasance, even though the pathway is longer, you can use continuation practice to defeat the illegitimate attack. You can come again. This is your worst case scenario. You get invalidated and you have to prosecute around it and you have to come again. You can come again and you can win. And I've seen that time and time again. So the process is long, but unless you root out that malfeasance where everybody can gang tackle, where all the procedural malfeasance can happen, it's an unpredictable and chaotic environment where you cannot reliably win. And so I think when you can reliably win, you can get investment on that long road. You can build a business, you can hire people, you can pour that money back into your tech, and there's a pathway. It's not an easy one, but there's a pathway.
I want to bring up an issue and have our panelists respond to it. And of course, everyone knows this, but it's such a key structural problem with the PTAB, and that is that the director of the U.S. Patent Office has so much authority over it, and what happens there. And of course, the director is politically appointed by the president, and typically, you know, who gets appointed? Well, typically it's going to be somebody that big tech wants to get in there. Otherwise, you know, so how big an issue is it that the director of the patent office typically it has ties to big tech? Who wants to respond to that? Is this I mean, what do you think? This is a huge issue, you know, this is a bias.
There's a dichotomy, or at least a tension between the decision in Arthrex that said that the decision at the PTO should be, or the PTAB should be reviewed by a person, a director who is accountable to the president and the voters. So there's a political oversight desire, at least on that side. But if the APJs are not themselves appear to be disinterested on their own merits, such as one step is making them not receive any bonus on performance, not having their supervisor give them the bonuses, and some of the other elements that Jonathan has raised and that Matt has raised in terms of incentives and in terms of appearance of impartiality. I think that will go a long way, even if there is a political director. The default should be the the judges should make a decision in which the review is seldom necessary. Let's put it this way.
From Patrick Buckley. Given any discovery in the PTAB to show the RPI, which I assume is real party of interest, is far too difficult, how can this be fixed?
Yeah, I'll jump in there. That's a good question. It also touches on I think a more fundamental problem with the PTAB process, which I've experienced as a litigator, and Jonathan mentioned as well too. You know, the key to litigation, or the key to getting to the truth, is discovery, and just the nature and the timing of PTAB processes don't really allow full discovery on a lot of issues. The PTAB APJs are very reluctant to even grant reasonable discovery, and you get far less than what you would get in district court. Now, district court might be overly broad and overly expensive at times, but there should be some happy medium. And with respect to the RPI issue, specifically the real party and interest issue, it's problematic because the PTAB is less likely to grant third-party discovery, meaning that if you wanted to go out and get discovery from a third party that you think is the real party in interest, it's just very problematic. And I don't know if there is a solution to it, because of the time constraints on the process. And I think that, again, goes to something that's just fundamentally flawed with the structure of the PTAB process.
So is there any way, this is from EC to Spain, what rate of invalidation do we imagine the PTAB will have if better evidence standards, i.e. clear and convincing, is implemented at the PTAB? What's it going to do to invalidation rates?
I can comment on it, having studied the standard of proof. In many cases, it's even in district court, whether clear and convincing or preponderance of the evidence is used doesn't really change the outcome, because some of these things are pretty clear about invalidity or prior art or anticipation. But there is a very important standard for the clear and convincing, and often on evidence that is based on testimony of a single party, and that is corroboration. We found that when a clear and convincing evidence standard is required, a mere statement by, for example, in public use by one witness isn't sufficient for clear and convincing. You need corroborated written material, for example. So there's some objective reasons why a clear and convincing standard has actually more teeth. Number one. Number two, the presumption of validity is obviously a strong point that goes with the clear and convincing. And then preponderance of evidence or equipoise values of evidence is not enough. So that's one element. The second is really something we discussed last time, and that is if the standards are the same, you can also enforce res judicata factors from a court. Typically, the Federal Circuit in the past has said, look, you can challenge the same patent in a PTAB because they have a different standard. Even though a court came to the conclusion that it's not invalid, we are going to let the PTAB go at it again because they have a different standard. That factual procedural issue alone has some value too.
I would add to that by saying in my experience, I don't think that while it should, I don't think that it will make a big difference. Because to give you an example, one of our IPRs we had instituted was 7 different references from different fields of technology. And they put in a petition saying you could basically draw elements out of all of these different publications from all different fields of technology, sprinkle obviousness magic over it, and invalidate the patent. And when the PTAB institutes, they're hemming themselves in to a position. And the view from then on, I found to be very self-justifying. We can spend enormous amounts of money. We can bring world-renowned experts to deliver expert opinions. We can pull out all types of technical testimony. The statistics bear out that it almost never makes a difference. Once they institute, they cancel. So what's happening during the proceeding, it is very hard to change whatever the standard.
So that brings up a point. I received an email from one of our members about a week or so ago, and I've been meaning to answer it. He's on the call here. He'll know that I did read it. One of the things he suggested is adding an obviousness standard, the one that was destroyed by the courts about, 4 or 5 years ago, into this legislation. And
TSM.
Yes.
TSM. Teaching, suggestion, motivation.
And would that have an effect on, I mean, surely it would have effect on Jonathan's patents. Would that have an effect on the invalidity rates, and would that be valuable to have written into this legislation? Anybody?
Well,
Judge.
I can comment a little bit. Now you're going a little different direction than addressing the structure and performance of the PTAB. Now you're amending Section 103 of the Patent Act. And that is, again, a different question than the PTAB. That's true that the main issue in an IPR is almost always obviousness. TSM remains the test used to provide evidence for the execution of the standard. It is not the standard itself. That was a misnomer by a group of misguided patent law professors at the time. The KSR decision was, again, a muddled decision, which didn't change too much. But while I'm happy to see improvements in the Patent Act, the PREVAIL Act is probably not the way to go about that.
But you do think that that would help, or you don't think it would help? The invalidity rate?
You know, that's an interesting question, Paul. My experience is when you ask Congress to start weighing patent law questions, they do about as well as the Supreme Court, which is they've got one shot in 10 of getting it right. And so I'm a little worried whenever people start to dive into substantive patent law reform. I would be happy to rewrite the obviousness provision if you give it to me. I wouldn't change any language in the statute, frankly. I'd deal with some peripheral issues, but the PREVAIL Act's not the way to go about that.
One thing about, of course, the whole obviousness question is it's so subjective, right? So if it's so subjective, if any venue is somewhat biased, they can come up with a reason to change from what the patent office said was non-obvious to saying it's obvious. And one thing we've talked about this before, but where you have something that has a bunch of elements that everybody has known about for years, nobody has put them together, and an inventor does, and it's highly commercially successful, that should be an indication of non-obviousness, in my opinion. So maybe that's part of the rewrite.
No, Randy, you're dead right, but all that's in the law right now. Everything you just said is in the law right now. The whole purpose of the rewrite of Section 103 in the 52 Act was to make it less subjective and more objective. And for the most part, that has worked. The most beautiful part of the U.S. obviousness test is its objective criteria, things like the market success, the licensing success, the unexpected results, the long felt need. These factors are considered in U.S. law and not in the law of any other country, by the way, which make our obviousness test the best in the world.
But it's not applied at the PTAB very well.
That's a different question. And that's why we address the structural malincentives of the PTAB in the PREVAIL Act. I don't think we want to go to changing the patent law to get at the problem. The problem, as you properly point out, is perhaps the way the PTAB implements the law, not the law itself.
So I've had people tell me, and I have not been through the PTAB. I lost my investors because the PTAB kill rate was too high, but I haven't been through the secondary damage. But what I've heard from some people is that they can't submit secondary considerations, and they can't talk about how the market turned and things like that when they're talking about an obviousness argument and the PTAB. Is that true?
And very often they don't give any weight to them.
Well, it's not true as a matter of law. As a matter of law, you are to consider the objective criteria. Now, Dirk, it sounds like you've had a bad experience there with some panel, and I hope the Federal Circuit would have the courage to overturn that.
No,
the law does allow those secondary considerations or objective criteria to be considered, and they should be.
Where this is breaking down is that without discovery, a company can say that your patent is obvious, and you won't get access to the thousands of lines of code that they wrote into the prior art system that they put forward that make the infringing functionality happen. So you won't see it. You won't see the evidence of the emails saying we need to study and copy these claims. And this is exactly what happened to us. We go to the PTAB, no discovery. Oh, this is all obvious. 7 references, cancel the patent. Some of them survive, get to district court, get discovery, voila. Very, very different obviousness analysis at that stage. So I
And
think
again, and
I wanna
that's a
talk
result of having both infringement and validity in the same proceeding, and that's the importance of it.
So one other thing that. Dirk just
Remember,
brought up-
that's where we started. That
Right.
was the big mistake, was separating those. And I think we said that from the outset.
One thing that Dirk just brought up is a Rule 36. So you don't get, often you get a Rule 36 from the Federal Circuit on these. So you don't get any real Article 3 oversight of this because they just simply say nothing. Is there a place in this to require the Federal Circuit to give an actual opinion on what goes on at the PTAB?
Matt, are you going to make me answer that one?
Should I go first?
I'm begging you to help me out here.
So, so that's an interesting question. I've actually written a law review article on that.
That's
and
right.
there's a argument that's floating out there that based on the statute, the Federal Circuit actually has to issue a written opinion. I personally disagree with that, but be that as it may, there are pros and cons of requiring the court to write an opinion, right? The pros are, like I think Paul's suggesting, you get more explanation of what the judges are thinking. That also, the con is that it does take time and effort. I was a clerk for Judge Michelle years ago, and it does take time and effort even to write non-precedential opinions. And as an advocate before the court on behalf of inventors and others, one of the things that goes unappreciated a fair amount is that the Federal Circuit is, I think it's still the only federal appellate court that gives oral argument to every represented party, right? Meaning that if you have an appeal to the Federal Circuit, you will get a day in court and you'll be able to stand in front of the judges and they will ask you questions and you'll have your attorney answer the questions. If you're at the Third Circuit or the Fourth Circuit, for example, your odds of getting oral argument are actually quite low, like 30 or 20%. Some other circuits are higher. So that's a, you have to balance that, right? Because the judges have only so much time. And so if you advocate for a rule that says the court has to issue a written opinion in every case appealed from the PTAB judges, then a reasonable response would be, okay, well, we're happy to do that, but we can't take the time and effort to invite everyone into the court for an oral argument on every case. And, I have seen, and I've been the subject of a Rule 36 decision once or twice, and it stings, and I don't like it because you spend so much time going to court, and a day or two later, you get this one-line order saying affirmed. And it's really heart-wrenching. And so I do wish that the court would issue more opinions, but I also think that there are a fair number of cases that they're fairly dealt with by just an affirmance and having your day in court and oral argument. Judge Rader may have a different view.
No, I'll add just one thing, Matt. I agree with everything you've said. The Federal Circuit has the lowest caseload in the federal judiciary. As a practical matter, 70% of its cases come from one administrative agency. They probably have more time than they're given us to respond. I too would urge that there be fewer Rule 36s and that the court provide us with the guidance that you're suggesting they should, Matt.
But
So
isn't lower caseload not necessarily meaning lower workload? I mean, there's quite a bit of work on those
In
cases.
in my era, Ron, that was true. We had a workload that was higher than other circuits because our cases were often patent infringement cases with 5, 10, 8 issues, which is the equivalent of 5, 8, 10 cases. And so our workload was the same, even though the case numbers were lower. Not true today, when 70% of their cases are single issue patent cases from the PTAB.
Mm.
So 70% of their cases are now the simplest possible kind of case to review. No, they're just the lowest caseload.
I mean, this sounds like a reason for ending Rule 36. Anyway, that's my point.
No, just for PTAB cases. The
Right.
point is that maybe you strike a balance and say for PTAB cases that require this review, let's have some exceptions about Rule 36 or do it only extreme cases, you know. So the distinction might be helpful, but as Judge Rader said, they cannot apply across the board, probably.
Sounds like a
particularly
reason
because
for
it
mutual
is the
consent.
Article 3 oversight of the invalidation of a personal property right. I mean, I think that the owners of those patents are owed that. Now,
Yeah,
maybe
that's a
not
good
in a
point.
court. You have
That's a
in
good point, because
regular
other circuits, when they do this, are reviewing other district courts, and so mostly here's a first instance of an Article 3 review. So that's a good point.
Right, and to emphasize what I said before, while I don't think under the current law there's any requirement to force the federal circuit to write opinions in every PTAB case, I complete wholeheartedly with Judge Rader and everyone else in that they should do it as much as possible, right? Because, like I said, I know as a practitioner how much time and effort I spend on some cases, and to go there and get that one-line rejection a couple of days later is stinging. But that's part of the job. That's what I get paid to do, and I'm happy to win or lose a case. I'm not happy to lose, but I'm happy to put it in my effort. But for an inventor to come to court and to spend all that time and effort, and yes, you get your day in court, but then you're rejected by a one-line order. I think sometimes if you haven't gone through it, the judges may not fully appreciate the significance of even what like a 2 or 3 page opinion could do in terms of explaining the process and the decision making.
So we've gone significantly over time here. I'd like to get summary thoughts from everybody. But first I'm going to give you mine. So I believe that the overall effect of the PREVAIL Act will be positive. I believe the changes are moving in the right direction. I believe the authors of this act are operating in good faith to try to fix this problem. But I believe also that the incentive model at the PTAB is going to retard its effect. And I'm not certain that there's going to be any real change in invalidity rates as a result of that. They have to have an invalidity rate significantly higher than the courts in order to attract petitions. And that is my main concern with this whole thing. But I'd like for each of you to give your thoughts on overall how you feel about this bill, so that we can try to put our policy together, and so the listeners here can understand how you feel. Judge Rader.
I think the PREVAIL Act is an important attempt to bring more balance into the PTAB proceeding. Will it achieve a complete balance? I don't believe that's possible for the reasons we've talked about. You've separated validity and infringement, and that cannot be corrected short of repealing the PTAB, and that's not likely to happen. In any event, the two provisions of most importance, the estoppel provision to make it more likely that the party has to select one forum, the PTAB or the district court, is very beneficial. And the burden of proof that honors the presumption of validity of these patents should also help bring more balance at the PTAB. I think it's a good bill.
Jonathan.
I agree very much with Judge Rader. I think that the bill represents progress that should be harvested, but it does not represent a destination. It represents some incremental progress. I think it has to be followed up with things to put more balance in the PTAB process to the extent that that process is going to continue, like unlimited discovery instead of none. I think it's much more important that it be moved to be equitable instead of to be quote unquote cheap. So in short, it by no means does this resolve the inequity of PTAB, but it reduces the collisions of inventors improperly with the PTAB.
Matthew.
Oh, thank you, Paul. I'll keep it short and simple. I concur with both Judge Rader and Jonathan. I think I'm not advocating for this bill on behalf of any client. From the perspective of an appellate litigator and a district court litigator and a PTAB litigator, my personal perspective is that there's likely to have a lot of beneficial effects if the PREVAIL Act does get enacted. Now, like Jonathan said, it's a battle of inches, and while it would be nice to have one bill that solves all problems, I don't know if that's possible. So hopefully some progress will be made here. Well, thank you very much.
Well, thank you.
Ron.
I agree. I agree with everyone who spoke before me on this issue. So I will just stop it here because I think the PREVAIL Act will be fortunate if it actually will prevail being enacted in Congress. I'm not sure it will. I think as it is, it has some significant benefits that would be opposed, and that's my concern.
Well,
we should support it in principle.
Yeah, Dirk, what are your thoughts?
Well, I agree with what everyone's saying on the call. I have a good analogy, which I think matches what's going on here. It's you're sitting on a plane and the plane's crashing because the wing broke off, and it's hanging on one metal rod. And someone somehow got on the wing and is trying to duct tape it back on. It's all fine, it's good. It's going in the right direction where it may delay the crash. But I feel like ultimately the way it's written, it's good, but there's also a lot of things missing, a lot of fundamental things missing. And I think for that reason, the plane ultimately will still crash.
Yeah, my thought is certainly a lot of, look, the more egregious aspects of the PTAB are addressed here. What will be the ultimate actual effect if this bill were passed? Hard to say, because again, you have structural, the way the thing is put together is biased. There are biases there for sure. And I think that the smallest, if you're a large company with lots of patents and lots of lawyers, I think it definitely provides a benefit. If you're a small entity, not as much. And so I know I want to thank, we've kept you guys here much longer than, well, it's an hour and a half. That's a good length, and thank you for being here. Judge Rader, Matt and Jonathan, thank you for giving us your opinions. You certainly have a lot of experience and knowledge. And to all of our viewers here, thank you for attending. And we'll be looking very closely at this, and we'll have an official position at some point in the near future. And again, our purpose is to actually restore the rights of inventors and startups. And it's so important for the country, so important for our future, the future of our kids. And a big part of it is staying ahead of adversaries like China. So thank you, everybody, for participating, and we really appreciate your support. Thank you.
Thank you.
Thank you.
Thank you.
We'll see you next time.